I've seen a lot of things walk through my courtroom doors over the years: arrogance, entitlement, people who've never heard the word no said directly to their face and genuinely don't know what to do with it. But the morning Cassandra Whitmore walked into my courtroom, and I do mean walked, the way someone walks into a room they already own, I thought I had her figured out in about 40 seconds. Everybody did. The gallery, the clerks, my bailiff, Dennis, who's been standing at that door for 18 years and who doesn't startle easy. We all looked at her and made the same assumption. It's the assumption I've made 1,000 times in this job, and it's served me well. Except that morning, it was wrong. Dead wrong. And the moment I understood why, the moment I asked the one question nobody else had thought to ask, the whole room went quiet in a way I've only heard a handful of times in 4 decades on this bench. That kind of quiet that isn't empty, it's full. Full of people realizing they made a mistake. I'm going to tell you about Cassandra Whitmore, and I'm going to tell you about the note. She arrived at 9:47 for a 9 o'clock hearing. Now look, I've had plenty of late defendants in my time. Most of them shuffle in apologizing, clothes wrinkled, excuse already half formed in their mouths. Cassandra didn't do any of that. She came through those double doors like the delay was the court's problem. 27 years old, 5'8", dressed in a silk blouse the color of cream that probably cost more than 2 months of my clerk Raymond's salary, tailored charcoal slacks, Prada heels, the kind with the little enamel triangle on the back. Her hair was blown out perfect, not a strand out of place, and she had one of those Bottega Veneta bags, the woven leather ones, chocolate brown, tucked under her arm like a paperback novel. She wore a watch that I later found out, because I always find out, retailed for close to $40,000. 2 attorneys flanked her. Not 1, 2. The lead attorney was a man named Gerald Fitch from a firm downtown that I know well, because wealthy defendants hire that firm when they want the kind of legal representation that comes with a golf handicap and a senator's cell phone number. Gerald was carrying a leather document case and wearing a suit that had clearly been made for him specifically, and he walked 2 steps ahead of his client with the confidence of someone who expects to be done by 11 and at lunch by noon. Her full name was Cassandra Eleanor Whitmore. The Whitmore family, for those keeping score, owned the 2nd largest private land development company in this part of the state. Her father, Everett Whitmore III, had a net worth that financial reporters put somewhere around $1.8 billion. Real estate, timber rights, a shipping logistics arm. The family had been in this county longer than most of the buildings downtown. Cassandra didn't acknowledge the bailiff when he directed her to the defendant's table. She didn't look at Raymond when he called the docket. She set her bag down on the table with a small, deliberate thud, pulled out her phone, which she placed face up in front of her, and crossed her legs. And she glanced across the room at the plaintiff's table, the way you might glance at something that had fallen off your countertop, briefly, without real interest. That's when I saw Patricia Okafor. Patricia was already seated. She'd probably been there since 8:30, which is what people do when they can't afford to be late, when they have to take a bus and transfer twice, and they're not sure how long it takes, so they add an hour just to be safe. She was 44 years old, a licensed practical nurse who worked the overnight shift at Mercy General 4 nights a week. She was wearing scrubs, dark blue, clean, pressed as well as scrubs can be pressed, with her hospital ID still clipped to the pocket because she'd come straight from a shift. I found out later she'd worked 11 hours that night and hadn't slept. Her hands were folded on the table in front of her. Still, deliberate stillness, the kind that takes effort, that you maintain because you know people are watching and you've decided they're not going to see you break. She had a name tag that said Patricia, and below her name, in smaller letters, the word nurse. She'd worked at Mercy General for 19 years, or 18, actually. I had to check the records later. 19. She had 2 daughters, Amara, 16, and Kezia, 12. She was raising them alone. Her mother lived with her and helped with the kids when Patricia worked nights. She drove a 2014 Honda Accord that had somewhere north of 140,000 miles on it. Because when you're supporting a household on a nurse's salary, you maintain the car you have. The case, on paper, was a civil matter, a parking lot incident. 6 weeks prior, Cassandra Whitmore had allegedly sideswiped Patricia's Accord in the hospital parking structure and driven away. Patricia had the make, model, partial plate, and a description of the driver. Cassandra's attorneys had filed 2 pre-hearing motions and a continuance request. The continuance had been denied. The pre-hearing motions had been denied, which is why Gerald Fitch looked the way he looked when he sat down. I noticed when Patricia pulled a folder from her bag that she'd organized everything with colored tabs. The kind of thing you do when you've never been to court before and you're trying to be thorough because you don't have an attorney telling you what matters. I've seen that before. I know what it costs a person to sit across from 2 lawyers in a room like this and still keep their voice steady. And I noticed one other thing about Patricia Okafor, though I didn't know what to make of it yet. She had a folded piece of paper tucked into the front pocket of her scrubs, small, white, folded twice. She touched it once when she sat down, the way you touch something to make sure it's still there, and then she left it alone. We got underway. I explained the proceedings. Gerald Fitch began his opening statement and managed to use the word circumstantial 3 times in 90 seconds, which is always a sign that the evidence is less circumstantial than the attorney would like. That's when Cassandra Whitmore leaned back in her chair. I want you to understand what I mean when I say she leaned back. She didn't adjust. She didn't shift. She leaned back the way someone leans back when they're watching television, arms loose, one elbow on the table, chin slightly up. And she sighed, audibly, with about as much effort to conceal it as you'd make sighing in your own living room. I set my pen down. I find that when I set my pen down and say nothing, it communicates more than most sentences. The courtroom got quieter. Cassandra's eyes drifted toward the window. "Ms. Whitmore," I said, "is there somewhere you'd rather be?" Gerald started to stand. I held up one finger. He sat back down. Cassandra turned to look at me. And here's what I saw. I saw a young woman who had, in that moment, decided that I was another version of every authority figure who'd ever asked her a question she didn't feel like answering. She gave me a look that I can only describe as patient tolerance, the look of someone waiting for you to finish so they can go back to whatever they were actually thinking about. "No, Your Honor," she said, flat, even. "Good. Then I'd ask you to treat this room accordingly." Gerald cleared his throat. Cassandra's expression didn't change. "I have a rule in my courtroom that I've held for a long time. Everyone gets the same temperature. The billionaire and the bus driver, the repeat offender and the first timer. I hold the temperature. The moment a judge lets her frustration show, she loses the room, so I held it." But I'll be honest with you, there was something about the next half hour that tested that discipline in a way I hadn't expected. Cassandra Whitmore didn't argue. She didn't fight. She radiated, I don't have a better word for it, indifference. A practiced, ambient indifference that felt less like a personality trait and more like protective gear. It had the quality of something learned, rehearsed over years in rooms where the only safe strategy was to want nothing, react to nothing, and wait for whoever was talking to finish so you could go home. I noticed it. I didn't know yet what to make of it. I filed it away. Anyway, we went on. Patricia's account was clear. She'd been loading nursing bags into her trunk at approximately 2:15 in the morning after a shift. She'd heard the impact before she saw what caused it. By the time she turned, she'd caught a partial glimpse. White SUV, chrome grille, one brake light that was slightly brighter than the other. She'd written the partial plate on the back of a receipt from the vending machine downstairs. She'd filed a report. The damage was $4,312 to repair. She'd been driving the car with a crumpled rear quarter panel for 6 weeks because she couldn't cover the repair and still make rent. She said this without drama, without asking anyone to feel sorry for her, looking straight ahead. Cassandra's second attorney, a younger man named Briggs, was typing on a laptop. Cassandra glanced at her phone. "Ms. Whitmore," my voice was quiet, "I don't believe I've authorized the use of personal devices in this hearing." She looked up. "Put the phone face down, slowly. The way you do something when you're complying, but you want the other person to understand that you find the request slightly absurd. I need you to understand something," I said. "In this courtroom, who your father is carries exactly as much weight as who Patricia Okafor's father is, which is to say, none." Gerald opened his mouth. I looked at him. He closed it. Cassandra's jaw tightened, just slightly. And then she said, And I want to get this right because the exact words matter. She said, "This is a waste of everyone's time. My car has a dash cam. If there was video, we'd have seen it by now," the gallery murmured. Patricia's hands, which had been still on the table, went very still in a different way, keyed up, like she was waiting. I looked at Cassandra. "As a matter of fact," I said, "the hospital parking structure has its own camera system. And yes, we do have video." I had it played. The footage ran 44 seconds. Security camera mounted high on the east wall of the second level of the Mercy General parking structure, or third level, actually. I keep picturing it as the second. The record says third. Timestamp 2:18 a.m. The image was clear. A white Range Rover entered the frame moving at about 15 miles an hour. Too fast for a parking structure, which is a whole separate issue, and clipped the rear left quarter of a dark blue 2014 Honda Accord that was parked in space 2G. The Range Rover didn't stop. The driver's window was visible for about 2 seconds. The lighting wasn't perfect, but it was enough. The courtroom was silent through all 44 seconds. I looked at Cassandra when it finished. Her expression hadn't changed much. There was something behind her eyes, but it wasn't shame, and it wasn't recognition of what she'd done wrong. It was calculation. She was looking at Gerald. Gerald was looking at his notepad. And then I asked the question. I want to back up for 1 second because I need to explain something. In my 22 years on this bench, well, 23 now, I lose track sometimes, I've developed a habit of watching defendants more than I watch attorneys. Attorneys are performing, defendants are reacting, and in those reactions, the unguarded ones, in the half second before they remember someone's looking, you see things. I'd been watching Cassandra Whitmore since she walked in, and something had been sitting wrong with me. Something I couldn't place. She wasn't performing confidence the way wealthy defendants usually do. She wasn't even performing contempt, really. She was performing nothing. And the nothing was too complete, too practiced, too flat. I've seen people shut themselves down like that before, and it doesn't usually mean what you think it means. So I asked Gerald Fitch and Mr. Briggs to step outside for 10 minutes. You could have heard a pin drop in that courtroom. Gerald looked like he wanted to argue. He didn't. They went. And when the doors closed, I looked at Cassandra Whitmore and I said, "Who wrote the note in your pocket?" The whole room went quiet. I mean quiet, the kind you can feel in your chest. Cassandra's hand moved, not toward her pocket, away from it, a micro flinch, the kind the body makes before the brain can stop it. Her jaw was set hard. Her eyes went to the table. "Your Honor, I don't." "You've touched that pocket twice since you sat down," I said. "The paper inside it isn't yours, or you'd have put it in that bag. You've been protecting it. Who wrote it?" Cassandra Whitmore, who had walked into my courtroom an hour earlier like she owned the building, looked, for the first time, like a 27-year-old woman who was very, very tired. She reached into her pocket. She unfolded the paper on the table. She didn't look at it. She pushed it toward me and she looked at the window. I read it, and then I set my glasses down on the bench. I don't do that often. The note was handwritten. 4 lines. I'm not going to read it to you verbatim because some things in my courtroom stay in my courtroom, but I'll tell you what it said in substance. It said, show up, keep quiet, let Gerald handle it, and sign whatever Gerald puts in front of you. If you don't, there will be consequences. Those consequences were spelled out in terms that were not ambiguous. They involved the apartment Cassandra lived in, which was in a building owned by the Whitmore Family Trust. They involved a monthly allowance that Cassandra received. And they involved something else, something I won't put into plain language here, but which I understood immediately and which explained every single thing about how she'd behaved in my courtroom that morning. The note was signed with a first initial and a last name. The last name was Whitmore. Everett Whitmore, her father. I called for a recess. I'm going to be honest with you. What happened in the next 45 minutes in my chambers was one of the more difficult conversations I've had in 2 decades on this bench. Cassandra sat across from me, just the 2 of us, plus my clerk. She was 27 years old. She'd been living in a building her father owned, on an allowance her father controlled, working for a firm that her father had arranged through a friend for a salary that her father had negotiated. She had a law degree that she'd completed, Barely, she said, because she'd been pulled out of the program twice at her father's insistence for reasons she didn't fully explain. She had been, for her entire adult life, managed. The word she used was managed. The parking lot incident. She'd been driving the Range Rover because Everett had a habit of handing her his vehicles to use when he wanted something done, because the car being in her name or the insurance being in her name created a buffer. Gerald Fitch was her father's attorney. The continuance requests, the motions, she hadn't made those decisions. She hadn't been told what the motion said. She'd been told to show up, sit down, and let Gerald do the talking. The note had been delivered to her apartment at 7 that morning by a courier. Now, I want to be very clear about something, because I've seen people try to use systemic pressure as a substitute for personal accountability, and I won't do that. Cassandra Whitmore drove that car. Cassandra Whitmore left that parking structure. Whatever her circumstances, whatever her father's control over her finances and her housing and her professional life, she made that choice. People in difficult situations make choices every day, and choices have consequences. But the case in front of me had changed substantially. What I'd started the morning thinking was a straightforward hit-and-run matter had become something more complicated. And the real damage, the real source of it, was sitting somewhere outside my courtroom in a corner office. I called Gerald and Briggs back in. I called the hearing back to order. I looked at Cassandra. Ms. Whitmore, you're going to be honest with this court, starting right now. And she was. What came out over the next hour was methodical and ugly. Cassandra confirmed on the record that the vehicle was registered in Everett Whitmore's name, but insured through a Shell LLC, and that she'd been instructed to use the vehicle 3 or 4 times a month for errands that her father didn't want traced to him directly. She confirmed that she had not, in fact, been the person who filed the insurance claim on the Range Rover afterward, that Gerald Fitch's office had done that. She confirmed that the note existed, and she told me verbatim what the consequences mentioned in it had meant. Some of that testimony I asked Raymond to seal. Gerald Fitch said very little. His client, his real client, wasn't in the room. Patricia Okafor sat at that table through the entire thing. She'd come in with colored tabs and a pressed set of scrubs and a folded piece of paper that she kept touching, and she listened. She didn't cry. She didn't react visibly. She just listened. And at one point, she took out her own piece of paper, her own note, it turned out, which was a list of repair estimates and out-of-pocket costs she'd written in a small, clear hand. And she put it on the table in front of her like it was still relevant, because it was. And she was not going to let anyone in that room forget that she still had a car with a crumpled quarter panel and 2 daughters at home and a bus she needed to catch. I sentenced Cassandra to 60 days in county jail, not work release, not house arrest, actual custody, to run concurrently with a 2-year suspension of her driver's license. 600 hours of community service to be served at Mercy General Hospital, specifically in the patient transport and family services units where Patricia Okafor worked. You know, folks, the placement mattered to me. I wanted the consequence to have a face. I wanted Cassandra Whitmore to spend her next year walking those same halls, checking into the same nurse's station, working alongside the woman she'd left alone at 2:15 in the morning in a parking garage with a broken car and no explanation. The gallery was very quiet when I read the sentence. The stirred, gasping kind of quiet I'm used to in big moments wasn't there. What filled the room was slower than that, a thinking quiet. I've learned to distinguish the two. In the 3rd row, I noticed an older woman, silver hair, a cardigan with a small brooch at the collar, who I later learned was Cassandra's aunt, her mother's sister, a person her father had apparently spent years trying to remove from Cassandra's life. She was crying, not in grief, in something closer to relief. I don't know that I've ever seen relief look quite like that before. Restitution to Patricia Okafor, $8,644. That number covered the vehicle repair plus the rental car Patricia had been renting in small increments to get to her night shifts. Odd number, real number, the kind of number you arrive at when you actually count everything. I also issued a court order requiring Cassandra's attorneys, whoever they turned out to be, going forward to have no contact with Everett Whitmore or his representatives in connection with her case. I referred the matter of the note and everything Cassandra had described about the LLC structure and the vehicle use to the district attorney's office. I referred it with a written summary. I included the sealed testimony. Everett Whitmore's attorneys contacted the court twice in the following month. Both times I had Raymond send the same response. The matter was under referral and the court had no further comment. Gerald Fitch did not appear in my courtroom again for 7 months. When he did, he was representing a different client, and he was considerably quieter than I'd ever seen him. Cassandra served all 60 days. I checked. No early release, no medical accommodations beyond what any inmate receives, no special designation. She was out in 60 days. She showed up at Mercy General for her first community service shift with a kind of wariness I recognized. The wary look of someone who doesn't know yet whether they've earned the right to be in a room. Patricia Okafor, from what the hospital coordinator told me, treated her like any other volunteer. Professionally. No coldness, no warmth. Professional. I thought that was exactly right. By month 4 of the service hours, something had shifted. I heard about it secondhand, the way you hear about most things, through the hospital coordinator, through Raymond, who has more contacts in this city than I do. Cassandra had started picking up extra shifts. Not required ones, extra. She was working in the family waiting room at the pediatric unit, helping parents fill out forms, navigating them through insurance processes, translating for families who didn't have someone to translate. She had a law degree, it turned out, and she knew how to read a policy document. And apparently, once she was in that waiting room without anyone managing her or directing her, she started using it. The hospital coordinator, a woman named Deborah, who has been running volunteers at Mercy General for 11 years and who does not impress easily, told me that Cassandra showed up on time, every single shift, that she brought her own coffee and asked for nothing, that she once spent 3 hours in the waiting room with a family who didn't speak enough English to understand what the surgical team was trying to explain to them. And she sat there and translated every word and didn't leave until they told her she could go. Deborah said she'd never seen that from a court-ordered volunteer. I told her I hadn't either. You know, I've been doing this work long enough to know what genuine change looks like and what performance looks like. The performance stops when nobody's watching. The real thing doesn't. Patricia told me about a year later that Cassandra had helped her older daughter, Amara, with a college application essay. They'd sat in the hospital break room for 2 hours going over it. She said she didn't know exactly when she stopped seeing Cassandra as the woman who'd left her alone in a parking garage. She said it didn't happen in one moment. It happened slowly, the way things that actually change usually do. Where was I? The restitution. Patricia got the check at 90 days. She had the car repaired. She also had enough left over by a specific amount of $812 to put the first month of driving lessons on deposit for Amara, who was going to need to drive once she went to college. I know that because Patricia sent me a letter. I get letters sometimes. Most of them I don't respond to because the professional distance matters. That one I kept. And Everett Whitmore, I'll tell you what happened there, though I'll keep it brief. The DA's office filed charges 14 months after I made the referral. Financial fraud related to the LLC structure, 2 counts, plus a separate matter that had apparently been building independent of my referral, but which my documentation had helped establish. 2 counts or 3? I'd have to pull the filing. The point is the referral mattered. That case is still moving through the system as of the last time I checked, and I won't speculate on outcomes, but I'll tell you this. When your father has been controlling your life through the threat of withdrawing the floor from under you, the apartment, the income, the access to a career bar, and that control ends because a court exposed it, you find out very quickly what you're actually capable of. Cassandra found work on her own, immigration legal services, pro bono clinic. She called the coordinator at Mercy General to keep her volunteer spot after her service hours were complete. They kept it. I've been doing this long enough that I don't get surprised much. But I'll tell you what still gets me when I think about that morning. The room full of people, My bailiff, the gallery, both attorneys, even me for 45 minutes, who looked at a young woman in expensive shoes with a designer bag and 2 lawyers and decided they understood her. We had her in a box by the time she sat down, and the whole thing cracked open because of a folded piece of paper in a scrub pocket and one question nobody had thought to ask. Real justice, the kind that actually does something useful, asks a harder question than who did it. It asks what is actually happening here, the full story, not the surface reading. And the answer to that question in this case was stranger and more human than anything I'd expected when I got to court that Tuesday morning. I've been on this bench long enough to know that the cases that teach you something are rarely the ones that go the way you expected, the ones that make you set your glasses down. Those are the ones that matter. That's what this was.